The other thing that I sort of pick up in what you said is the emerging, what I would think to be a false wisdom that ex-ante regulation is needed in digital markets. And so now we are seeing every jurisdiction in the world that doesn't yet have a DMA think, oh, this is the digital economy, let's go ex-ante. So that is an interesting new stereotype that we are seeing emerging. And to use a French word, I would say this is a faux ami, a false friend, the term ex-ante, where what we are talking about is essentially, do we want per se prohibition rules against platform? It's not ex-ante regulation, it's just moving from the rule of reason to a full per se approach and structural presumptions. And maybe if we manage to set the discussion this way, we would have more handle on that conversation by recalling a lot of people that US antitrust law started with per se prohibitions only to move away from them very quickly, thinking it's completely wrong. The first cases of the Supreme Court were per se cases. And Europe started with per se prohibitions in Article 85, at the time 81, 101, only to move away from them, thinking it's completely wrong to do that. So we have a ton of historical evidence that the way to start a new question is not through the per se box. And so I think we could do a lot of good to ourselves if we were using the right words to talk about this. This is not ex-ante regulation. This is just pure per se prohibition approach in the digital economy.